John Lacossi here, InternetMarketingExperience.com, along with Philip Nicolosi, JD, Internet Legal Armor. So today, Phil, we're going to do a video on the 6 critical branding mistakes that a startup or even a current company can make. And we're kind of going about this a unique way because we are going about it from a legal perspective versus just what a normal brand consultant would tell you. So let's go ahead and dig right in.
Sure.
The first critical branding mistake that a startup could make is not choosing a business name that can function as a trademark. Would you mind going into a little bit of detail about that?
Yeah, and let's start by describing two distinct, separate items. One is a trade name and one is a trademark. And what I mean by that simply is first, when you choose a business name, you want to understand what is eligible for trademark protection and what a trademark is. Most trade names, which are business names that businesses use to hold themselves out to the public, that's a trade name. Most trade names are trademarks, but not necessarily. And the important thing to understand is that you always want to make sure that your trade name, your business name, is also functioning simultaneously as a trademark or a service mark if you're a provider of services as opposed to goods. And all that means is that you're identifying the source of the services you're providing or the goods that you're selling using that mark, using that brand name. If it's a source identifier, as they say, then it is a trademark or a service mark. So really the important thing to understand is just to make sure that you're always using your business name slash trade name to identify whatever it is you're selling or whatever services that you're offering.
Got it.
Now, let's one second important point about that though that I'll also make is you want to make sure you probably understand what a good trademark is. I mean, if we're talking about a trademark, you know, make sure that you understand when you choose a solid trade name or business name that it is eligible for protection. So what we mean by that is you want to understand that generic names, really what I'm saying is that make sure you don't choose a name that's generic and ineligible for protection by the United States Trademark and Patent Office. Excuse me. You'll want a name that's suggestive or fanciful, somewhat, somewhat beyond the mere designation of generic or even descriptive. Okay, those are the terms that the USPTO will use. So really, it has an example, which is probably the best way to describe it. Google. Google, of course, is not a generic name. It's not really a descriptive name. It's really something just totally arbitrary and made up. Okay, it's what the USPTO calls arbitrary or fanciful. That's the standard for it. That's what you want. Something where it's unique. And as long as you understand the basic rule of avoiding anything generic or that merely just describes something, okay, you don't want a trade name that just describes a product that you're selling, okay, like pizza pie. That's probably not going to work. So just avoid the basics, and
Well,
that's really it.
Let's give an example real quick before we move on to the next one. And
Sure.
that would be like, let's say, for example, we're in Rockford, Illinois, right? And we want to start a landscaping company. What you're saying is we shouldn't call our company or shouldn't lean towards calling our company Rockford Landscaping.
Well, not necessarily that. You shouldn't use any terms that actually describe the services that you're providing in a generic or a merely descriptive way. So if you're trying to register the mark and the mark just says landscaping, now Rockford Landscaping would qualify it, of course.
Okay.
But if it just says landscaping or landscaping services, I suppose,
Okay.
probably something like that. I think
Would
that
be
would
too
be
general.
it would be merely descriptive of the services being provided and not necessarily denote a unique source identifier. So that's probably the distinction. And maybe that's not the greatest example, but that's basically the idea. You can't merely describe what it is that you're offering to sell or the services you're providing. It's got to be elevated from that. It's got to be unique, okay, in some sense. And it can't be generic, of course.
Got it. Got it. Um, let's go on to the next one.
Sure.
So the second critical business mistake that somebody can make in a startup situation is to forget to search, search, search. Mind going in a little bit more detail about that, Phil?
Yeah, absolutely. I mean, we just talked about trademarks and trade names, and that's great if you found one and you think that it's eligible for trademark protection and it's a strong trade name. But the problem is it could also have been taken by somebody else. And if you fail to search on the search engines or on relative databases, industry databases, and stuff that relates to what it is you're doing. If you don't do, a good enough search and you miss the mark being used by somebody else in a confusingly similar manner, okay,
Mm-hmm.
the same line of work or the same industry, or substantially similar goods or services that you're providing, if you miss that because you don't do a Google search, for lack of a
Mm-hmm.
better word,
Mm-hmm.
then you're going to be in trouble because that's potentially going to be trademark infringement.
So, that's something that we could do at home. That's something a startup, an entrepreneur could do using their computer and Google. But, is there more of a professional service that can be purchased from an attorney specializing in internet like yourself, where you can give them more of an official clearing that, hey, okay, yeah, that business name would be good to use? Would they be able to purchase that kind of service from you?
Yeah, absolutely. And that's what a trademark attorney, one that's able to register
Mm-hmm.
your mark with the federal government, is able to do for you. You know, I myself do it. We offer
Mm-hmm.
two packages actually. There's mere registration, and then there's what you were just talking about, actually doing the work, doing the
Mm-hmm.
search, and providing an opinion. And most trademark attorneys actually have comprehensive software that will make it easier on them. It'll
Mm-hmm.
it'll compile all the results, and then that way you just analyze what's been presented to you, and you can make a decision for your client,
Mm-hmm.
or help them make a decision. So yeah, absolutely. They can do it at home themselves too if they could at least. I mean, they're not an attorney; they can't form the opinion, of course. But what they could do is they could probably at least see if something's there or not there,
Mm-hmm.
and if there's a conflict or they think that there's something that's close, then that's
Mm-hmm.
where they'd want to obviously talk to an attorney.
Mm-hmm.
But you'd be surprised. I mean, you do a Google search and you go deep enough, and 9 times out of 10, unfortunately, if you have a good name and it's not super unique,
Mm-hmm.
could be taken, and chances are that it is. So that's why it's always going back to the first point. It's always
Mm-hmm.
good to get the most unique and arbitrary name that you can.
Mm-hmm.
But if you think you've done that, make sure. And that's the
Yeah.
point of what you were
And you
saying with
can get
search.
professional help to do that then.
Absolutely.
Got
Absolutely,
it.
and you should.
Mm-hmm.
You can feel free to see if anything's not there, but when you find something, you absolutely should not try to do it at home, as they say.
Right, right. Let's move on to the third one. The third critical mistake somebody could make is assuming a business organization provides trademark protection.
Yeah, right. And what we mean by that point is when you organize your business, whether it be a corporation or an LLC, you can't just assume. And a lot of my clients that come to me that have already started a company do assume this, and this is a myth, and this needs to be corrected. Do not assume that because you've registered and organized that business with, say, the state of Illinois or wherever you are, that also means that that mark, your business name, your trademark or service mark, is also protected. It's not. All they care about is whether the name that you're using, the legal name that you've registered with the Secretary of State, whether that's on file with them with a different entity. And
Mm-hmm.
if it's not, it's going to be made available to you. That doesn't mean that you get to use that mark in commerce. That doesn't mean that it's not infringing upon another trademark or service mark that was there before your use of that mark or your company's use. So don't be confused, and don't ever make the mistake of thinking just because I've got this shiny new LLC or corporation
Mm-hmm.
that my name is not protected and
Mm-hmm.
I'm not going to infringe upon anybody else's rights. It has nothing to do with trademark law.
Interesting, interesting. Um, what about number four, forgetting about the domain names for a potential new business?
Yeah, and again, then this whole process that we're talking about, it's all interrelated.
Mm-hmm.
And in trying to choose a good brand name to avoid these mistakes, don't forget about choosing the corresponding domain names.
Mm-hmm.
And then there's two sub points I'll kind of make here, okay? But
Okay.
the first one is don't forget to do it because, me personally, I always start there first,
Mm-hmm.
actually. I want to see, in my assessment of whether it's available and whether I might be infringing or my client's name might be infringing upon an existing trademark or service mark. I almost immediately go to a GoDaddy or another service provider and try to find out if the domain is there for the taking, and if it is, of course you're going to want to secure that because
Right.
if you've got a trademark slash business name, the .com and the .net and the .info are very important. .biz even
Mm-hmm.
.org if you're an organization, those are all very important domains, top level domains to have.
Mm-hmm.
And if you don't secure those, you're missing out on brand protection and a very important piece of it. So not only is it a great way to try to determine if the mark that you've chosen, the name you've chosen, is available for use and won't infringe upon anybody else's rights, but also just don't forget to secure
Mm-hmm.
the basics, the .com, the .net, .biz, .info, .org, maybe .us, maybe
Mm-hmm.
.co. I mean, there's no need to go crazy, but every business should really secure the basics, and even common misspellings that you think are might commonly happen when searching in the name. Something to keep in mind for brand protection,
Mm-hmm.
because it's a lot cheaper to register a $14 or $15 domain now,
Mm-hmm.
and maybe go maybe have more than you think you want to protect. Well, okay, what happens if someone does end up down the road taking that domain from you? You're going to spend far more money than you would have had to maintain that variation.
Mm-hmm.
And so I think personally, those spin-offs like the .info, the .us, probably worth it to protect the whole gamut of your
Yeah.
brand. Yeah, and the other sub point I'll make is don't make the mistake of thinking that the domain name by itself, just because you've registered that, is also going to be eligible for trademark protection or
Mm-hmm.
service mark protection. Again, a trademark and service mark has to be a source identifier. It
Mm-hmm.
has to clearly, or it has to identify the source of who's providing these goods or the services. And a domain, the domain that's also your business name is going to do that.
Mm-hmm.
But the point here is just don't go pick some random domain and then think that that domain is going to be eligible to be protected as a trademark, because if that domain again is not a source identifier, it will not be eligible.
Got it. So the science behind choosing the domain name is way more important than people think.
From a legal perspective, absolutely, and from a brand protection and long-term strategy of preservation, absolutely.
Number five is failing to secure intellectual property rights. We kind of talked about the domain name itself, but what other facets would fall underneath that, Phil?
Yeah, and this is pretty simple. In talking about all these names, business names, trademarks, we're also talking potentially about design marks. You've got a
Mm-hmm.
name, and
Mm-hmm.
some businesses are going to, of course, have a corresponding logo, and they'll have that artwork created. Make sure you secure the rights to that intellectual property by always getting the right type of legal framework in place for the people that create that work.
Yeah.
So, real quick example: you picked out a great name,
Mm-hmm.
and you know it's eligible for trademark protection. You've talked to someone like me. We're going to go forward. We're going to register that. You're going to use it in commerce, and you say, well, I've got an idea for a logo also, and I'm going to have somebody design it.
Mm-hmm.
Well, understand that the creator of a creative work, okay, always owns the rights to the intellectual property. That's always considered the owner of that creative work, whoever creates it. So for you to acquire the rights to your own intellectual property, because you're commissioning somebody to do it, so quite frankly it's yours and it should be.
Mm-hmm.
But if you don't secure the rights legally, the right way of securing those rights, it won't be yours. So
Mm-hmm.
you've got to make sure you have either a work for hire agreement or an assignment in place from these creators that you're dealing with. Now, if it's an employee, of course, that's different, because they're working for you and they're already deemed under U.S. copyright law to have been transferred there. They never had the rights because they're employees, basically, under U.S.
Mm-hmm.
copyright law. But independent third-party freelancers and these people you may hire, of course, they do automatically have rights, and therefore those rights need to be transferred to your business or to you
Mm-hmm.
if you're a sole proprietor. So when commissioning third parties to do these logos and similar things for your website and graphic works and anything that's a creative work,
Mm-hmm.
just make sure you always have a work for hire agreement or a written assignment in place, transferring the full bundle of those rights over to you, the full bundle of copyrights or to your business.
So don't just take their word for it when they say, "Yeah, we'll give you full exposure." Actually, have something in writing.
Oh gosh, no, you can't take their word for it. The law
Mm-hmm.
demands that you have something in writing
Mm-hmm.
for the rights to be fully transferred in a legal manner
Yeah.
that you can enforce later if push comes to shove.
That includes, headshot photography, that kind of thing as well.
Anything that's a creative work,
Mm-hmm.
absolutely.
So, Phil, number six and our final critical branding mistake is not using your mark in commerce or reserving the future rights of use. Um, and I think what comes to mind in my head when I think about this one is somebody's got a great idea and they reserve a domain name and then they just sit on it, thinking, "Oh, I've got it secured. I don't need to worry about it anymore. It's there when I need it." 2 years goes by, they do nothing. Somebody else comes along and potentially starts to have a similar idea. Can you go into some detail about this one?
Yeah, and you actually just kind of hit the nail on the head. I mean, it's really as simple as that. You have a great name. You've picked out you've got business aspirations. You've gone in all the steps that we just talked about.
Mhm.
You've ensured you've met all those, and you're down to the final step. And whether you decide to register a trademark or not, you've got to actually use that name in commerce to, offer the services or sell the goods that you're providing in connection with that name. If you don't do it, you never acquire rights.
Yeah.
So, and let's talk about the distinction between trademark registration and common law rights, and that's where this comes into play. Um, if you register a trademark at the federal level, you do have automatic rights into that mark to use it, and you've reserved those rights. Now you can have a use in commerce application, or you
Mhm.
can have a reservation of use in commerce application, and both registrations are going to secure you or your business's rights into that trademark or service mark. However, you don't necessarily have to do that to acquire the basic rights of ownership, if you will, into a mark.
Okay.
You can also just use it in commerce. And
Mhm.
once you use a mark in commerce, in connection with what you're doing in terms of selling goods or providing services, the meter starts to run.
Mhm.
So when the meter runs, you're creating, your rights are starting to be established. And of course, some mark owners have stronger rights than others.
Mhm.
But you can't have any rights if you don't start, and you've got to start the meter running, and you've got to get the ball rolling by actually, using the mark in commerce. Otherwise, you better register it, and you better
Mhm.
do an intent to use with the federal government, the USPTO, and you better reserve your rights to use the mark in commerce.
Mhm. Is there anything in particular that a startup should do to timestamp that date and time when they use the mark in commerce,
Um,
or just?
if they're using it in commerce, there's going to, typically be a record of it. But that's a
Mhm.
good point.
Mhm.
You should always have a general awareness of what the first date in
Mhm.
use of commerce was, in
Mhm.
interstate commerce, commerce in general, and especially interstate commerce,
Mhm.
for purposes of trademark registration down the road. Yeah, you'd want to document all that, but using your mark in interstate commerce, you're going to have a web presence, and of course, as you know, with a web presence,
Mhm.
you're going to be able to document, not with ease, but you'll be able to document within a fair degree of certainty when you first use that mark with web archives and things
Mhm.
like that. But that's actually a really good point, and you know what? To expand upon that, yeah, I would probably recommend taking screenshots and doing
Mhm.
what you can to establish when that first date of use in commerce and in
Mhm.
interstate commerce is with your mark. And so whatever you think you need to do to memorialize that, screenshots of the browser with the date and time, stuff
Mhm.
like that,
Yep.
that's a great idea. It's a great point.
John Lacoste, InternetMarketingExperience.com, here with Phil Nicolosi, Internet Legal Armor. Please be sure to follow our channel for more videos to come, and visit InternetLegalArmor.com for some more information and tips. And we will see you in the next video.
Thanks, John.